Who do I have from the jail? Zachary Ladd? No. Who's at the jail? I have a gentleman at the jail. What's your name? I don't think he has audio. I have a guy at the jail in orange. What is your name? Can you hear me? All right, Miss Adams, will you let the jail know that whoever it is doesn't seem to be able to hear me? All right, so I have Phoebe Meir appearing on behalf of the people. So Mr. Goldstein, how do you want to proceed with Miss Hannawalt?
Your Honor, there is another felony matter that's set for an exam on the 6th of July. I think probably it would be best if we could get that matter to a prelim. Either it gets found over, or we can then put all the cases together, or it gets dismissed and we can go from here on these cases.
All right, Mr. Malaro, I have Miss Rice present. So Miss Rice, want to come up to the podium? All right, this is in the matter of the people of the state of Michigan versus Stephanie Lynn Rice, file number 21-20664, FH and 22-20716, FH. I have Salvatore Malaro appearing on behalf of Miss Rice, and I have Phoebe Meir appearing on behalf of the people. So, couple things. Miss Rice, Mr. Coast has provided some information on Monday, June 5, 8:49. Mr. Coast stated that Miss Rice had a swab done on June 1 of 2023. She did not have the money to pay for it, but Mr. Coast did perform the test. Miss Rice, just for future reference, small children, it's never really appropriate to bring them here.
I understand.
The drug screen returned positive for methamphetamine, 1,121 nanograms per milliliter, which is actually at a dangerously high level. She was here today for contempt of court sentencing for failing to call on a daily basis directed. In this case, it's another violation.
Can I speak on this?
Not yet. So I had released her on a pair bond again. I mean, I've taken her into custody and released her before. Mr. Malaro, I'm going to ask that Mr. Coast do a contempt of court warrant on the violation of drug testing, but due to the levels, I have some grave concerns. It would be my intention to take her into custody today. Mr. Malaro, I know that she will probably want to speak with you.
This hearing gets serious very quickly. The court isn't dealing with one isolated mistake here. The judge is looking at a pattern, missed requirements, repeated court problems, and now another positive drug screen. But what's interesting is that the biggest twist hasn't even happened yet.
Judge, if I may?
Yes.
So I have one more file. She's in the jail. And if the court's willing, I'd like to take care of that case. And then I'd like to come over and maybe we can get some progress done on Miss Rice's files, including what the court has just brought to my attention. So.
Okay. All right, Ms. Rice, have a seat.
Do you guys want me in person upstairs for that too?
You don't have far to go, so if you want to, yeah.
Yeah, it might be a good idea, Phoebe.
And maybe you and Mr. Malaro can chat in the jury room or something.
Okay.
I'll be over in a few
And Mr. Coast, you could probably pop back in.
Okay, sounds good, Judge.
Thank you.
Thank you.
All right, Ms. Adams, could you have Mr. Coast come in, please? Or is he
He was
in?
doing a
Okay.
Huh?
he was doing a drug test and stuff.
Oh, okay, he might be busy. All right. So Ms. Rice, why don't you come up and we'll take care of you. All right, this is in the matter that people of the state of Michigan were Stephanie Lynn Rice, file numbers 21-20664 FH and 22-20716 FH. I have Salvatore Malaro appearing on behalf of Ms. Rice, and I have Phoebe Meir appearing on behalf of the people. Darren Post is present, is our pretrial services coordinator who did administer another test today. So we are here on a couple things today. One thing we are here on is a sentencing on a contempt of court, as well as a pretrial conference on the underlying file. Ms. Rice is charged with aggravated stalking, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine. We were previously set for trial, and now we are again set for, we are set for trial for August 1 for a one-day trial at 9 a.m. So with regard to first the pretrial today, Mr. Malaro, how would you like to proceed?
Your Honor, I think if I understood Ms. Meir correctly, do you want me to do it or you want to do it? Okay, Ms. Meir is going to tell you what we're going to do.
Yeah, so, well, maybe, I guess I'll have Mr. Millar correct me if I'm wrong, but the people are in a bit of a, I guess, uncomfortable situation or bad situation in these cases. In preparation for the trial, I did meet with some of my witnesses, the victims in this case, and they are quite frankly just fed up with this at this point. And I, obviously I could make them come in and testify, but at this point, I don't think they really want anything to do with this. So it does put me in a difficult situation. So what I am asking of the court is a bit unconventional, but I think their exasperation with this case and with Ms. Rice does have to do with obviously the time delays, the fact that we've been set for trial before, I think even a year ago, and Ms. Rice has, on a number of occasions failed to appear. She now has these new drug screens. So I guess what I'm asking for the court, again, it's unconventional, but that I will dismiss these felony charges as well as the PPO violations and ask the court to sentence Ms. Rice to the maximum on the contempt of court. I think that would accurately reflect the delays in this case and the fact that I do have to dismiss because of the delays in this case that were mostly at Ms. Rice's cause, just her, again, not appearing, these positive tests.
And this is where the case takes a completely unexpected turn. The prosecution is actually asking the court to dismiss the underlying felony charges. That sounds like a victory for the defendant, but there's a catch: they're asking for the maximum contempt sentence instead. So the original case may disappear, but the consequences for violating the court's orders aren't disappearing with
Dismissing
it.
the underlying file as well as PPO violations.
Judge, no objection to any of that. The only other issue is clarification. I did inform Ms. Meir that I would be arguing the issue of how much time
On the contempt court.
that the court give. Yes.
Okay. All right. So, very good. I will move to the issue of sentencing on the contempt court. So look through this file. Let me go through this file. Waiver, discovery, adjourn. And this has been going on for about 2 years now, and it's a serious case. So, Ms. Rice, you should be grateful that it's being dismissed. Let's see. Trial release order. Yes. Are there new charges from this alleged incident that occurred the other day?
So there are new charges pending in in district court that have already been filed. I think it's a trespass, but it might be just an assault.
I think it's an assault and battery, Your Honor.
And then Mr. Coast advised us of an incident yesterday that may also have new charges. Those will obviously be dealt with in district court separately.
Okay.
And I, again, don't want to discuss these charges, but I think at this point, it's best to move forward and not make Ms. Rice's ex and son testify if it's not necessary.
All right, so, with regard to sentencing today on the contempt court, are you ready to receive that, Mr. Malaro?
And Your Honor.
All right, do people have any position on sentencing before the court proceeds?
Just like I said, I do think the maximum on the contempt of court would accurately reflect the delays in this case. Time is often in favor of the accused, and it certainly has worked in Ms. Rice's favor in this case. But that being said, I think the maximum on the contempt is more than fair, given her number of positive tests, including today being positive. And given, I could go back and see how many times this was delayed based on her non-appearance, but I don't have that figure right in front of me on both cases. And as well, that's not even counting the district court where she had failed to appear and was arrested in district court before it was found over. So, thank you.
Mr. Malaro, anything you'd like to say on behalf of Ms.
The
Rice?
defense is trying to make the judge see the person behind the paperwork. They're pointing to her children, counseling, housing, and the progress she had made before things started falling apart again. And honestly, this is why these hearings are complicated. A court can recognize someone's struggles without ignoring the rules they've been
On
ordered to
behalf of Ms.
follow.
Rice?
It would, Judge. Judge, I have represented Ms. Rice, I think, almost since the time I started the public defender's office. So I'm very well acquainted with Ms. Rice and all of her legal troubles. That being said, Judge, none of this is an excuse for her behavior, but 3-4 years ago, it's very well. First of all, and I think this court's also well acquainted with Ms. Rice as well. Whatever happened prior to that is certainly played a great deal on her emotion, how she handles things at an emotional level. And I think as we all know, when we let emotions take control of our decision-making process, we usually make bad decisions. And Ms. Rice is engaged in counseling and therapy and will probably need it for a very long time to help her get past that area where she lets her emotions take control of her decision-making process. That being said, there are times where she is she has some good attributes. One is she's a good mother. And I know that this court could argue and not actually argue, but state that how can you be a good mother if you're using drugs that you shouldn't be using? And there's no debate with that. But by all accounts, through her CPS case, which I handled, and through today, her primary focus for the last 3 years has been her children. She has 2. She is the primary caregiver. The fact that CPS has closed the file on her shows that she's committed to continuing to be a good mother.
That was quite a while ago.
About 10 months, maybe. I think it was December, October. But she has continued to make strides to getting housing, getting the services she needs. Guardian, last time we were in on that case, had no issues with her as her parenting skills. Ms. Rice faces many challenges, Judge. She was in district court yesterday and I was present for that hearing, and the judge, spoke to her, and one of the things that's apparent is Ms. Rice has so much burdening her. Children, these pending cases, which I think if we can get them, if these are finally resolved today, will be a great help in getting her past that. Remove those stressors that I think will help her life settle down somewhat. She can spend more time focusing on her children. I think she tends to put too much emphasis on things and uses that as a way to justify some of her behavior, such as not appearing in court, not attending certain things. And I certainly understand the state's point of view on this and their situation. But I think this is a good resolution. I think that the longer she's in jail, the more at risk her children are. And so with all of that being said, Judge, and knowing Miss Rice and knowing that she actually has a case, she has to be in district court on this assault charge this morning yet. But I told her to come here first, and she did. I'd ask the court to use its wisdom and fashion the most appropriate and lenient sentence as to any jail time as it possibly can. That would be our request on Ms. Rice's behalf.
Ms. Rice, is there anything you'd like to say on your own
Now we're
behalf?
hearing directly from Rice, and the tone changes completely. She's not speaking through her attorney anymore. She's trying to convince the judge that the drug test results don't tell the whole story, while also explaining how much she believes she has at stake with her children. Whether the court accepts that explanation or not, you can hear how much pressure
Anything you'd
she's
like
under.
to say on your own behalf?
Yeah.
Okay, I need you to go stand at the podium for me.
3 years ago, when Eleanor was born, at Toledo Children's Hospital, her meconium came back with methamphetamine in it. And I had not touched it. I had never touched it. And so they did a very extensive and intrusive test through ProMedica. Eleanor had zero withdrawal, zero. They monitored her for 6 hours. She had zero withdrawals. Not one withdrawal did she have. None. Because I wasn't using that drug, but the drugs that I take through my Dr. Noble. And Dr. Noble told me and my case manager this in her office. They cause a false positive. When Memphis was born, his meconium came back with the same exact test results, but they didn't even go through what they went through. They didn't call CPS. CPS never got called because they knew that it was verbatim the same exact as Eleanor's. My kids will lose everything, and I have worked really hard to get where we're at. We will lose it all. When I went to jail this last time, I lost my daycare for my kids, which is why I had to bring them to court. I reapplied. I started all over. I started all over all of my stuff again. This thing downstairs that happened, I need to be able to fight that because it's a lie. I didn't put my hands on her. She put her hands on me and my kids.
All right, so ma'am, I don't want you to talk about any pending cases because
Sorry.
everything you say can be used against you because this is a court record. All right, so don't talk about events that occurred on new cases. Say that for your parents.
I know that my kids will be in foster care if I go to jail. I don't have anybody to watch them. Their dad has not seen them in over 2 months. I've climbed out of my trenches. I've climbed out of them by myself. I've worked by myself with them in tow, and we need each other, and they need me, and I'm not using.
Mr. Coast, you administered a test today to her, is that correct?
Yes, ma'am.
And did she test positive for anything?
Tested positive for the THC, amphetamines, and also methamphetamines.
Now, we know she's on Adderall, but her levels were extremely high, so that would be more than, and it would cause a positive
Correct,
test.
and to her previous test was a swab that was actually sent to the lab. I did talk to the lab, They said the only thing that would make methamphetamine turn positive is methamphetamine. Or through a false positive because of the Adderall.
True.
All right, so Ms. Rice, now I realize that you completed a CPS case, you had your children placed in your care, and the case was closed in October. But what I will tell you, what I've seen is you go downhill since then. I'm talking now, not you. So on April 17th of 2023, there was a motion affidavit and bench warrant because you failed to call in to pretrial services coordinator. They're imposed on a daily basis. There were no call-ins from 4/10 of 23 to today. It's date on April 17th. Let's see. I have a drug screen collected April 6th of 23 that shows a positive test for methamphetamine. So then, let's see, we'll go to the next one. On May 16th of 2023, you failed to appear for warrant on May 16th of 2023. Issued a bench warrant. Let's see, this one was filed April 18th. Call in. Let's see. Prepare bench warrant arraignment. I have a failure to appear for bench warrant arraignment on May 16, signed by me on May 16. I have pretrial release order. You have to comply with CMH recommendations and medications. And we've had multiple tests that were sent in on a swab showing your levels are dangerously high. So,
Which
no,
my
Ms.
doctor.
Rice, I'm talking. So, Ms. Rice, I have great concerns about your mental health, your physical health, and your just defiance from day one of the court's orders, and also a downhill spiral that I'm seeing in your behavior. Court's orders are in place, and while I have great sympathy for your trials and tribulations, I also feel that you have taken advantage of that to some extent, trying to manipulate the court. But based on just the overwhelming issues I've had for you, with you and your failure to comply with court
After
orders.
hearing both sides, the judge makes the decision. The original charges are being dismissed, yet the court still finds the repeated violations serious enough to impose 93 days in jail. And that's the part that can be easy to misunderstand. Dismissal of the underlying charges does not automatically erase separate contempt consequences for violating court orders.
I think you got off very lucky today because the charges are being dismissed, but I am going to sentence you to court or to jail for 93 days.
Please don't do my kids will be in foster care. Please
Well,
please
get
judge.
credit for any time you've already served.
Can you please
You're
just
outside.
give me
Thank
a
you.
try? Please,
No.
judge. Please, I'm begging you. I'm begging you. My kids are gonna be in foster care. I'm begging you. I'm begging you. Don't touch me. Don't touch me. I can't do 93 deals. Can I please, can I bond out? Can I pay?
You're gonna
I
get,
can't do this, please.
that's it. You're gonna get credit.
Please. This is why I don't come.
You're gonna get credit.
Let me go, please.
No.
Please let me go. Okay, but I can't breathe. I can't breathe this way. I can't breathe. I can't breathe. I can't breathe. I need some water. I can't breathe. I can't breathe. Please, can I have some water? I can't breathe. No, I can't walk. I can't walk. No, I can't. I can't walk like this. I can't do it. I can't do it. I don't talk to me like that. I can't do it. I can't breathe.
You're not ready to use
I'll take it off.
But I've heard that for 4 years. So I can take it on the last year.
3 years. Every time we're in court, I hear
And
that.
that's what makes this ending so difficult to watch. There are clearly consequences to repeated violations, but there's also a person experiencing the immediate impact of that sentence. This hearing isn't simply about whether someone won or lost. It's about how quickly a series of missed obligations and unresolved problems can turn into a much bigger legal crisis.